Order in the court. Welcome to 5-Star English, where we dive into the world of law and order to boost your legal English confidence and curiosity. Today we cover 15 essential law and order phrases divided into 3 levels. Beginner phrases for everyday legal talk, intermediate expressions useful in courtroom and reporting contexts, and advanced terms for deeper legal discussion. You will hear clear definitions, sample sentences to practice aloud, and a final role-play mock trial to use the phrases naturally. By the end you will be ready to argue a point, describe a case, and sound more confident in legal English. First phrase is law of the land. Law of the land. This phrase means the rules and laws that everyone in a country must follow, and that form the basis of legal order. Use it when you want to emphasize that a rule is established and authoritative. Now let's look at a couple sample sentences. You can practice saying the sentence also.
The Constitution is the law of the land and must be respected by all officials.
When a new policy is passed, it becomes the law of the land until it is changed by lawmakers.
Next phrase is above the law. Above the law. This idiom describes someone who behaves as if they cannot be punished or held accountable by the legal system. It is often used critically when officials or powerful people avoid consequences. A related idea is that in a fair system no one should be above the law.
The public was angry because it seemed the minister thought he was above the law.
No matter how powerful you are not above the law in a democracy.
Next phrase is lay down the law. Lay down the law. This means to state rules, limits, or consequences clearly and firmly, so that everyone knows what is expected. You might hear it when a judge, manager, or parent sets strict conditions. Synonyms include set rules or enforce rules.
When the new principal arrived, she decided to lay down the law about school uniforms.
The judge had to lay down the law after repeated courtroom interruptions.
Next phrase is take the law into own hands. Take the law into own hands. This means to act outside the legal system to punish or correct a perceived wrong instead of reporting it to the authorities. It is generally risky and illegal because it can lead to more harm. Use it to warn against vigilante behavior.
Neighbors warned him not to take the law into own hands after the break-in.
Even though he was angry, he chose not to take the law into own hands and called the police instead.
Next phrase is letter of the law. Letter of the law. This refers to following the exact wording of a law rather than its intended purpose or spirit. It is useful when discussing technical compliance versus ethical intent. A related phrase is spirit of the law, which contrasts with this idea.
The company followed the letter of the law, but many criticized it for ignoring the spirit behind the rule.
The inspector checked every detail to ensure the firm complied with the letter of the law.
Next phrase is jury is still out. Jury is still out. Use this when the outcome of an issue is still uncertain or experts have not agreed. It works well in courtroom reports and everyday decisions. A fun note: it borrows imagery from juries that must deliberate before deciding.
About the new evidence, the jury is still out on whether it will change the verdict.
When asked if the policy will reduce crime, analysts said the jury is still out.
Next phrase is throw the book at. Throw the book at. This means to seek the harshest possible punishment under the law. Often used when prosecutors or judges want to set an example. Use it for severe penalties or strong enforcement actions.
The prosecutor decided to throw the book at the repeat offender.
After the major fraud was exposed, regulators promised to throw the book at the responsible executives.
Next phrase is case in point. Case in point. Use this phrase to introduce a clear example that illustrates your argument. It is handy in legal discussions and presentations when you want to back up a point with evidence.
The recent appeal is a case in point showing how the courts interpret the statute.
When arguing for reform, she used the high-profile trial as a case in point.
Next phrase is beyond reasonable doubt. Beyond reasonable doubt. This is the highest standard of proof in criminal law. The jury must be almost certain of guilt before convicting. Use it when discussing convictions and the burden of proof required for serious charges.
The prosecution must prove the defendant's guilt beyond reasonable doubt for a conviction.
After careful deliberation, the jury concluded the evidence did not reach beyond reasonable doubt standard.
Next phrase is plead the fifth. Plead the fifth. In U.S. law, this refers to invoking the Fifth Amendment right to avoid answering questions that might incriminate you. It's commonly used in legal and political contexts, and can be controversial when used by public figures.
When asked about the missing funds, the witness chose to plead the fifth.
He decided to plead the fifth rather than risk self-incrimination during the investigation.
Next phrase is kangaroo court. Kangaroo court. This term describes an illegitimate or unfair proceeding where decisions are biased or predetermined. Use it to criticize sham trials or rushed internal hearings. Historically, it suggests a system that jumps to conclusions like a kangaroo.
The disciplinary meeting felt like a kangaroo court with no chance to present evidence.
Critics called the investigation a kangaroo court because witnesses were ignored.
Next phrase is hung jury. Hung jury. A hung jury occurs when jurors cannot agree on a verdict after deliberation, which can lead to a mistrial and possibly a retrial. Use it to describe deadlocked decisions in jury trials.
After days of debate, the panel announced it was a hung jury and the judge declared a mistrial.
The defense celebrated because the hung jury prevented a conviction this time.
Next phrase is litmus test. Litmus test. Originally a chemistry term, this idiom now means a decisive measure that reveals whether something passes or fails a standard. In law and politics, it's used to describe a single issue that determines support or opposition.
The candidate's stance on corruption was the litmus test for many voters.
For environmental groups, the new regulation served as a litmus test of the government's commitments.
Next phrase is prima facie. Prima facie. This Latin term means that on first appearance there is enough evidence to support a claim unless it is rebutted. Lawyers use it to describe cases that deserve further consideration based on initial facts.
The prosecutor presented prima facie evidence that the defendant was at the scene of the crime.
If the claimant can show a prima facie case, the defendant must provide counter-evidence.
Next phrase is statute of limitations. Statute of limitations. This term refers to the maximum time after an event within which legal proceedings may be initiated. If you wait too long, the claim may be barred. It's crucial to know these deadlines in civil and criminal matters.
The victim could not file a lawsuit because the statute of limitations had expired.
He filed just in time, narrowly beating the statute of limitations. Now, let's test your understanding of the idioms. Choose the correct word that goes in the blank. In this example, the sun rises in the morning, so the answer is C, sun. Okay, let's get started. In our country, freedom of speech is considered the blank and must be respected by everyone. Some officials acted like they were blank, refusing to follow rules that apply to everyone else. When the coach arrived, she had to blank to make sure the team followed the schedule. After the vandalism, a group of neighbors wanted to blank instead of calling the police. The judge admitted the evidence because it met the blank, even though the spirit of fairness was debated. Despite weeks of debate, the blank about whether the new policy will help remains. The prosecutor decided to blank the defendant to send a strong message about the crime. Her suspension is a perfect blank of how the school enforces its rules. To convict, the jury must be convinced blank that the defendant committed the crime. During the hearing, the witness chose to blank rather than answer potentially self-incriminating questions. The union leaders argued they had been tried in a blank because the hearing had no fair procedures. After 3 days, the trial ended with a blank, and the judge declared a mistrial. For many voters, the candidate's stance on privacy was a blank for whether they would support them. At first glance, the prosecutor had a blank case, enough to move forward to trial. The lawyer argued the claim was invalid because the blank had already expired years ago.
That concludes our Law and Order lesson. If you like this class, please subscribe for more 5-star English lessons, and thanks for watching.